Hi students, the next chapter in company law is company meetings. What is a meeting? Meeting is any gathering or assembly or coming together of two or more persons for the transaction of some lawful business of a common concern. That is, in companies, the shareholders are scattered in many places. So, to take some important decisions as the shareholders or the owners, every year definitely they will meet. So, there must be a meeting, it must be conducted every year, and there are various types of meetings. The various types of meetings can be divided into three types. Number one is meeting of members and shareholders. Number two is meeting of directors. Number three is meeting of other meetings. So these are the three kinds of meetings. One is members and shareholder meeting. Next one is director meeting. Third one is other types of meetings. These are the three major kinds of meetings. In case of first one, we will discuss. The first one is the meeting of members and shareholders, which is very important aspect in the examination point of view. What is the meeting of member and shareholders? The meeting attended by all the members and the shareholders of the company. This is called as the meeting of members and shareholders. There are four types of meetings which a member or a shareholder attend. Number one is statutory meeting. Number two is annual general meeting. Number three is extraordinary general meeting. And number four is class meetings. Now we are going to discuss about the various types of meeting by members and shareholders. The first type of meeting attended by the shareholders or members is a statutory meeting. What is a statutory meeting? Statutory meeting is the first meeting of the company, and it is conducted only by the public company, and the private companies, they are exempted from conducting statutory meetings. It is the first meeting and it is conducted only once in the lifetime of the public companies. These meetings must be held within after 1 month from the date of incorporation and before 6 months from the date of commencement of business. That is, after incorporation and getting the certificate of commencement, the meeting must be conducted after 1 month, and before 6 months it must be conducted. So every company, every public company must conduct in that manner. The important matters discussed in the meeting is regarding the issue of shares, debentures, or raising of capital, or modification of any contracts mentioned in the prospectus. These are the matters discussed in the meeting, and the main purpose of the meeting is to have an introductory session about the company, because it is the first meeting of the company. So who are the members, who are the shareholders, who are the debenture holders, who are the directors, like that. Some introductory session is the main purpose of this meeting. The board of directors must prepare and send to every member a report called statutory report at least 21 days before the day on which the meeting is to be held. In statutory report, the various aspects relating to the formation of the company and some details will be there recorded. This is regarding the statutory meeting of a company. The next meeting is the annual general meeting. It is also called as AGM. AGM is every company, every year, annually there will be a meeting. Every company must conduct. It is compulsory for every company, for both private and public, other than one person company. It is a compulsory meeting. In a year, at least once a meeting must be conducted. That meeting is called as annual general meeting. It is conducted only once in a year. The time gap between the two annual general meeting is 15 months, and the first annual general meeting must be conducted within 9 months from the date of incorporation. And if there is any default in holding or conducting the AGM, every officer in charge of the conducting shall be punishable with a fine of rupees 1 lakh. The AGM must be held on a working day during the business hours at the register office of the company or any other place within the city, town, or village in which the register office of the company is situated. What are the matters discussed in AGM? Four ordinary businesses or four ordinary matters were discussed. Ordinary matters were the consideration of the annual accounts, director report or auditor report, declaration of dividend, appointment of director in the place of those retiring, appointment of auditors and fixing their remuneration. These four are the ordinary matters and they are called as ordinary business. And if any matter other than the ordinary business is transacted, then it is called as a special business, and it must be mentioned in the notice of the meeting which is sent to the members, and along with an explanatory statement which is explaining about that special business. This is the next important meeting in the company, that is annual general meeting. The next type of meeting is extraordinary general meeting. It is a meeting attended by the shareholders and the members. As the name itself implies, it is an extra meeting. It is also a general meeting, but it is an extra meeting. Annual general meeting is an ordinary general meeting, whereas extraordinary general meeting is extra meeting. Why extra meeting is conducted? If every year only annual general meeting is conducted, yearly once AGM is conducted. If any matter which cannot be postponed till the conduct of the next AGM, then the meeting in this AGM it will be discussed, which cannot be postponed and it is to be discussed immediately. AGM is convened and it is conducted by the directors. Who is going to conduct the extraordinary general meeting? Number one is by the board of directors. Number two is board of directors will conduct on the requisition of members. If the board of directors is not conducting, then the requisition is themselves will conduct the EGM. Then the fourth one is by the Company Law Tribunal, National Company Law Tribunal. These are the four persons. They will conduct the extraordinary general meeting. Regarding the provisions of EGM, number one is a board meeting is to be convened to decide about the date, time and place of the meeting. And all the matters discussed in EGM is only special business and it is not ordinary business, because ordinary business will be transacted in AGM, whereas special business which cannot be postponed will be transacted in EGM. So EGM, all the matters were special business only. Then in the board meeting, the directors have to decide about the resolutions to be passed in the meeting, what are the businesses to be transacted in the meeting. Next one, a 21 days notice must be circulated to the persons who are eligible to attend the meeting, and the quorum for the meeting is also to be ascertained. Quorum, which is the number of members who is going to attend the meeting and make the meeting valid. That is called as quorum, which we are going to discuss in the next aspect. Next, after the passing the resolution in the meeting, a copy of the resolution must be filed with the ROC within 30 days. This is regarding extraordinary general meeting. The next type of meeting is the class meetings. Class meeting is regarding the shareholders meeting, that is preference shareholder meeting, the equity shareholders meetings. Class meetings are the meetings which are held only for a particular class of shares. For in case of a cumulative preference shareholder meeting, that type of shareholders will attend that meeting. This is regarding the class meetings. These are the various meetings of members and shareholder. The second aspect is the meeting of board of directors. Board of directors it is also called as board meeting. Every company shall hold the first meeting of the board within 30 days from the date of incorporation, and thereafter the board to meet at least once in every 3 calendar months. That is, every year at least 4 meetings must be conducted. In the board meeting, the important discussions will be discussed in the board meeting. In case of every company, a meeting of its board of directors shall be held at least once in every 3 months, and at least 4 such meetings shall be held in every year. This is regarding the meeting of board of directors. Next one is the other meetings. Other meetings is a meeting of the debenture holders and the meeting of creditors. The debenture holders meeting, the debenture holders will attend and the matters relating to the debenture holders will be discussed in the meeting. In that type of meeting, the shareholders, they won't attend that meeting. Like that, the creditors meeting, the creditors will attend the meeting regarding their aspects. These are the various types of meetings. It is a very, very important aspect in case of company meeting. The next important aspect in company meeting is the requisites of the meeting. Requisites of the meeting is the essentials of a valid meeting. What are the essentials of a valid meeting? A meeting to be valid, the following essentials must be present. Following requisites must be present. Number 1 is the proper authority. Number 2 is the notice of the meeting. Number 3 is the quorum for the meeting. Number 4, the chairman of the meeting. Number 5, minutes of the meeting. Number 6, agenda for the meeting. Number 7, proxy for the meeting. Number 8, voting and poll. Number 9, resolutions. These are the various requisites. Now we are going to discuss about each and everything separately. Number 1 is proper authority. Who is the proper authority to conduct a meeting? The board of directors. The board of directors are the proper authority to conduct a meeting. Number 2 is notice of the meeting. What is notice of a meeting? To every shareholder or every member, a written notice in email or in a direct by post. Like in any form, a notice must be sent to every shareholder and every person eligible to attend the meeting. That is, a 21 days clear notice must be sent before the meeting to all the members and other parties entitled to attend the meeting and vote at the meeting. Then what are the contents of the notice? The notice must contain the date, time, place and the agenda, that is the program of the meeting. And if any special business to be transacted in the meeting, it must be explained along with the explanatory statement, and it must be annexed with the notice. This is regarding notice of the meeting. Number 3 is the quorum for the meeting. What is a quorum? Minimum number of members who must be present in the meeting in order to make the meeting valid. That is, in case of a private company, 2 members must be personally present in case of a quorum. Whereas in case of a public company, it is based on the number of members. If the public company have below 1000 members, quorum is 5, and if the number of members in a public company is 1000 to 5000 members, the quorum is 15, and if the number of members is above 5000, the quorum is 30 members personally present. This is called as the quorum for the meeting. Next one is the chairman for the meeting. Chairman is the presiding officer of the meeting who takes the necessary steps for the orderly conduct of the meeting. Generally, board of directors act as the chairman of the meeting. Otherwise, some person will be elected in the meeting itself and he will act as the chairman of the meeting. What are the duties of the chairman? The chairman will see to the proper conduct of the meeting or the orderly conduct of the meeting, to see that the business is conducted according to the agenda of the meeting, and to decide whether the motions are in order, to see that the minority views are heard, to exercise his casting vote to decide the majority. What is a casting vote? If any, in a resolution, if any vote is cast, like voting is there, and to decide the majority, chairman is having the one vote, that is called as casting vote. Next one is to count the votes and declare the majority. This is regarding the chairman of the meeting. Next one is the minutes of the meeting. Minutes is nothing but the proceedings of the meeting which is recorded. What are the discussions made in the meeting which is recorded in a separate book called minutes book, which is also maintained by the chairman of the meeting. And the minutes book must be maintained and it must be prepared within 30 days from the conduct of the meeting, and it is kept for the inspection of the members of the company. This is called as the minutes of the meeting. Next one is the agenda for the meeting. Agenda for the meeting is the things done or the businesses transacted in the meeting. In order to transact the business of the meeting systematically without any omission, that is, agenda is nothing but the program schedule of the meeting. Next one is the proxy. Proxy is a person, a member who is eligible to attend the meeting. If he is not able to attend, he can appoint another person to attend the meeting, like an agent. This is called as proxy. It is a form. Proxy, it is a form to be filled and it must be submitted in email or directly to the company before 48 hours. That is called as proxy. And the proxy form, without depositing a proxy form, a proxy cannot attend the meeting. This is called as proxy. Next one is voting and poll. Voting and poll is every matters in the meeting that is to be discussed. It is called a motion, and the motion, if it is coming into the for discussion, sometimes a voting system will be implemented. The voting system may be voting by show of hands, voting by poll, or voting through electronic means. These are the requisites relating to the voting and poll. And the last one is the resolutions. Resolution is the decision taken in the meeting. There are three types of resolution. One is ordinary resolution, second one is special resolution, and number three is resolution requiring special notice. Ordinary resolution is the resolution with simple majority. There are certain matters which require ordinary resolution, which are given below, like that of to issue the shares at discount, to rectify the name of the company, like some ordinary matters which require ordinary resolution. The next type of resolution is the special resolution. Special resolution is nothing but the resolution passed with 75% majority. Example, if number of members present in the meeting is 100, at least 75 members must vote in favorable. That is called a special resolution. There are certain matters which require special resolution. The matters were to alter the situation clause of the memorandum from one state to another, to alter the register office, to change the register office of the company from one state to another, which requires special resolution. Like that, to alter or change the name of the company, to change the objects of the company, to alter the articles of association, to issue right shares, to issue convertible debentures, like the various matters of importance, the matters of certain importance which require special resolution. The next one is the resolution requiring special notice. Resolution requiring special notice is nothing but the resolution which requires a special notice. It is also a type of ordinary resolution. A notice shall be given to the members not less than 14 days before the meeting. The object of this resolution is to give the members sufficient time to consider the matter and to give their views. The following were the matters which require special notice. Number one is to appoint an auditor, a person other than the retiring auditor. Next one is to resolve at an annual general meeting that a retiring auditor shall not be reappointed. Next one is to remove a director before the expiry of his period of office. Number 4 is to appoint another director in the place of a removed director. These are the various matters which require a special notice. These are the various types of resolutions. These are the important aspects regarding the requisites of valid meeting. And the next one is the important questions which is repeatedly asked in the examination. That is the different types of the meeting of the shareholder, the different types of resolutions passed in the meeting. Next one is the requisites or the essentials of valid meeting. Next one is the powers and duties of the chairman. These are the various important aspects repeatedly asked in the university examinations. Then if you are interested in my videos, you can subscribe to my channel, give your valuable comments and your suggestions in the comment box. And you like my video, you share my video to your friends and other students who are studying BCom and other subjects relating to company law. Thank you.